All right, folks. So we have a panel that largely hasn't met each other yet, so we're delighted to have them on stage together. The next panel, and this is actually a wonderful discussion following Chairman Larson's keynote. Chairman Larson has been really interested, as you know, in permitting and the transactional side of things, and so we decided that it would be great to have a panel discussion on some of those emerging trends in groundwater transactions, and specifically about what we mean when we talk about a groundwater market. Sometimes we talk about it as this, big monolithic thing, and so we've invited a group of experts to come down and break it down for us. So to do that, I'm going to introduce to you your moderator, Kodi Sawin from the Sawin Group, to lead this discussion. So let's welcome them this morning.
Well, thank you very much, guys. This chair is for a very tall person, of which I am not. So I want to just set the stage for the panel first, and then we'll introduce our panel. I was actually asked to set the narrative for the panel by reflecting on the last 10 years of groundwater transactions using my professional experience. So I started in water in the private sector, developing groundwater projects for investor-backed companies starting in the early 2000s. My early years included leasing, permitting processes at different groundwater districts, as well as studying and evaluating potential markets. This was also roughly around the same time that new groundwater districts were being formed after Senate Bill 1. Over the years, I worked on several projects. In around 2008, I reached out to a guy named Ross Cummings of Blue Water Systems with a potential business opportunity, and that led us to pursue a 40,000 acre-foot permit amendment that provided the basis for the Vista Ridge project. So I was on the Vista Ridge project for around 9 years, starting with the permit amendment, moving to the contract execution with the city of Saws, and then worked on significant portions of the right-of-way and easement acquisition. So I've seen the nascent water development industry grow and have some modest success. And so what this panel is about, and I'll kind of start leading into that, in roughly the same time period, around 14 years, I also watched and listened to hundreds of hours of GCD and GMA and legislative meetings. In that time, I continue to come to the same conclusion that policy discussions are a reaction to an unclear market, and often that they actually often focus on the supply side solutions to the exclusion of clearly defining what the market is. And that brings us to our panel discussion today. And what are the emerging trends in groundwater transactions, water rights acquisition, and groundwater valuation? And what is the market that we're responding to? So I'm going to do a brief introduction of our panel so that we can get directly to the heart of the matter. Kristen Fancher, attorney at Fancher Legal. Kristen will discuss groundwater rights and groundwater leasing for us today. Jason Hill at JT Hill and Company. Jason will focus on transactional aspects of water rights. And then we're also lucky to have John Tracy here, director of the Texas Water Resources Institute at Texas A&M, and he'll help us better understand groundwater valuation. So to start out, I'm going to ask Kristen, what trends have we seen in groundwater rights and groundwater leasing in the last few years?
Great. Thank you so much, Kodi. I appreciate it, and I appreciate the opportunity to be here today, so thanks, Sarah and the Planning Committee. You know, first, when we had a call on this, and we spent a lot of time discussing it, so we said, okay, we'll try to get to the heart of the issues for you guys. But the main thing is when you frame this discussion up, you certainly, the first question that I always ask when I get a call about this is, okay, where in the state is it? Because obviously what's going on in West Texas does not carry muster in South Texas and East Texas and North Texas, all of which there are groundwater transactions going on. So first off, where in the state is it? Second, who is the end user? municipal use, obviously, and those transactions are going to be a lot different than the oil and gas transactions going on in West Texas, for example. And then third, also, is it going to just be a sale of groundwater, or is it a conveyance of a property right? So, and even with that third question, there's a lot of sub-questions there as well. So it's, like we talked about, it's honing in on exactly the specifics, because you'd be surprised how often I get the phone call and it's just because your brother-in-law has a certain transaction that occurred in West Texas, it does not mean, just west of the Metroplex, it's going to be the same. So I think that for me is something that I continue to see is, let's hone in on exactly where this transaction is taking place, and let's educate ourselves about what the market is there.
And then we'll move on to Jason, if you're ready, Kristen. Jason, what transaction trends or challenges are we seeing?
I think, what's interesting is that over the years, the sort of the dynamic of what makes up the landowner profile is changing. And that can add to a certain level of complexity that maybe might on the surface go unnoticed. For example, a lot of transactions from 20, 30, 40, even 50 years ago, and I'm talking about, one landowner selling, an estate of some type, either a fee estate or a groundwater estate, to a city or to another ag producer. You're usually dealing across the table with family members, the individual property owners that own those properties. Well, over the course of time, those landowners have moved on, and now those assets are transferred into family partnerships, which are managed by trustees. And your dealings with the landowners across the table, and what somebody who you may have a good working relationship with or a level of confidence in to have good faith and fair dealing and strike a good deal with, now we're in the hands of a trustee who is operating under a fiduciary obligation to the trust, and your negotiating position can be significantly different. That's a challenge, but it's just also a reality in a lot of transactions, and it changes the dynamic of the negotiation in several instances. Also, I think I would say the level of complexity in the issues to go through in a groundwater transaction may be a lot different today than they have been before. There were, I don't want to say there were unsophisticated transactions made 50 years ago. But with the level of interest involved behind a transaction, where financing is involved, the question of what kind of title do you take when you buy and when you sever out a groundwater estate and you purchase the severed groundwater estate? Are you going to get a general warranty? Are you going to get a special warranty? Are you going to get a deed with no warranty whatsoever? All those have big implications on what financiers are willing to put their money behind and what they're not. And then, of course, sort of the topic du jour is the fallout from day and the relationship between a groundwater estate and a mineral estate. I think the issues that go behind that are pretty complex, can be pretty complex as well. There is a relationship between the mineral estate and the surface owner, or the surface estate rather, that implicates the ability of the producer to use groundwater for the support of exploration and production activities. What kind of implications do that have on the groundwater estate that you're now severing and trying to sell, or that you're trying to purchase? Is it encumbered with this general reasonable access in the mineral lease? If it's an unencumbered mineral lease, that's one thing. If it's a mineral estate that's been leased up for a dozen years, you're probably going to have some challenging terms in the mineral lease that you have to take into account in the transaction. So none of these are overcomable obstacles by any means, but they do affect what ultimately you would attribute to be the value of the resource in place, and so it does trigger a different level of complexity than maybe has occurred in the past.
Well, then let's go on to John, and we'll kind of do a little bit of roundabout after we get through some of these questions, but what is the broader context of groundwater valuation as academic and applied practice, and what are you seeing as a trend?
Okay, thanks. I'm going to follow up a bit on what Kristen was pointing out, in that when you start looking at this idea of a groundwater market, and the thing is when I talk to a lot of people that talk about groundwater markets, they start thinking about, well, how much is my groundwater worth? And they think about it in terms of like, an oil and gas market, where there's a fairly stable price, and we think, oh, wow, it was $100 a barrel a while back and $50 a barrel now or recently. And you think that's a big change. No. I mean, the valuation of groundwater is so highly dependent on not just the location, not just what you're using it for, but the weather outside. And because of that, you're not talking, doubling or halving the price of groundwater. You're talking about orders of magnitude change in what someone would be willing to pay for groundwater, depending on where you are, what they want to do with it, and how much it's been raining lately. And so that makes it really difficult to start establishing markets. The interesting thing about being in Texas is that Texas actually has the ability to sell groundwater. Most of the other states can sell the right to access groundwater or the right to access surface water, and that's very different than actually selling the commodity there. And, kind of with that as I guess I'd say a preface, it's really good to think about how, what exactly we're talking about when we're talking about, trends in groundwater markets and the valuation of groundwater. And so one thing I would like everybody to do, if you really want details on this, there's a good paper by Gabriel Collins in the Texas Water Journal. And full disclosure, TWRI is one of the members of the Texas Water Journal. And so it's a journal that we actually produce. But it is a really good paper by a professor from Rice University. And it actually does probably the best summary of recent groundwater transactions and different ways that you can go about approaching understanding how much that transaction is worth. And it covers the entire state in the most recent, it's a very good summary article. And so if you want to get down to the details, I'd say go look up the article, Gabriel Collins, Texas Water Journal. Now with that, I'm going to attempt to summarize some of what he says in the paper. The bottom line is that when you start looking at water in general, it's what would be called an intermediate product. That is, when you think about water, it really doesn't have value until you use it to do something. You use it to grow pecans. You use it for oil and gas production. You use it for green lawns. And if you think about what was the value of water right in the middle of Hurricane Harvey, it was negative. And what was it during the drought? It was very high. And so when you start looking at what are the trends in the valuation of groundwater, it's not so much what are these long-term trends, is it going up or going down, but it's these trends in how much is a barrel of oil worth? Because when you start looking at it for fracking water, the valuation can be very, very high. There's some instances where you can show transactions where they were paying $24,000 an acre foot for groundwater. On average, when you look at the Texas market in the oil and gas producing regions, it's probably more like $4,000 to $5,000 an acre foot. When you start looking at how much would someone pay for groundwater for producing pecans, it's kind of interesting because you almost have to ask the question, well, is this something they're going out in the open market paying for, or is this something where they ended up in a legal dispute where they sort of finished a lawsuit with takings? And this is an example that Gabriel Collins puts in his paper. And on the open market, it would be $1,000, maybe $1,500 an acre foot. However, when you look at the case in the Edwards Aquifer, the payout in terms of the lawsuit was $25,000 an acre foot. So I think the lesson learned there is wait till somebody tries to take your groundwater, then sue, and you'll probably get a lot more for it than actually using it to produce something. Now that probably, it's a little bit of a glib statement, but it is interesting when you look at what would be considered the valuation, not so much a transaction, but how much did they get for not using their groundwater. The legal cases have always led to much higher valuation than actual water market transactions. So from, I guess I'd say the groundwater owner's perspective, you have to go through a lot of heartache and some uncertainty, but there seem to be bigger payouts in the end there. And the other thing to think about is, the situation where Kristen was talking about, where you're actually talking about selling groundwater as a commodity versus selling access to groundwater, either through groundwater estate transaction or in the case, for example, Vista Ridge, of leasing the groundwater rights. And that's where things get kind of interesting, because it's very clear that when we start looking at selling groundwater as a commodity, the big market is oil and gas exploration, that is the fracking water. And that's fairly high, but that's going to be short-term, very limited amount of market, very geographically limited market, and also they will eventually use up and find all the oil and gas, and then there won't be a market for that anymore. Whereas if we look at the market where we're talking more in line of the lease payments, that's probably where the future trend goes. And we can look at Vista Ridge and see that I believe the lease price for the water, or the price for the water, would be $460 an acre foot, I think is the contract price for the water. But the water delivered to San Antonio, when you account for all the costs of the pipeline, the energy, so forth and so on, is around $2,000 an acre foot. And so you can look at that and say, well, that's $460 an acre foot, but if you look at what the landowner would actually get, it's 10% of that, which is $46 an acre foot. And then they're only going to get that if they use the groundwater. Now, the plans are to use the groundwater, but then you have to look at, well, what are the alternatives to spending $2,000 an acre foot? And that's something where we will see how economically efficient ASR is, water conservation methodologies. And so it's really difficult to say it's worth $460 an acre foot, because to the landowner it may be worth $46 an acre foot, and that's only going to happen if they pump the groundwater. So there's a lot of ifs, and ifs. So trying to summarize this up and being the perfect academic here, I can say, we don't really know what the trends are, but there are a couple of take-home points. One is the trend in the valuation of groundwater will tie into what you're using it for. That is, if the prices of pecans go up, the value of groundwater in the El Paso area will go up. If the price of oil and gas goes up, the value of groundwater for fracking will go up. And if the prices of homes go up, for example, in the Austin area or San Antonio, the valuation of groundwater will go up, because water is needed to service those homes, and people who buy more expensive homes will be willing to pay more for water supplies to keep the homes and the landscaping up. And so looking at the trends, what you can say on the pecans and the oil and gas is like, that's going to go with the market and what's out there as competitors for pecans and oil. When we start looking at the valuation for residential and urban use, that's definitely going to continue to increase, because not just are we having higher populations coming in, the prices of housing in these areas is going up. And so we can anticipate sort of a continuing rise in the valuation of groundwater for the urban setting, but probably in the agricultural and oil and gas setting to be just to go where the end product goes. Thanks.
Very interesting, thank you. So let's go on to how those trends, I'm sorry, I need my glasses on, apologize about that. So let's just go back to Jason here for a second, and how does groundwater estate severance change how groundwater transactions occur?
Well, I would say that the big differentiator on severance is whether or not, well, the question that drives, I think, the severance issue is whether or not you're going to sell the molecules of water that are produced, or whether or not you're going to sell a property right. Or in most instances, the sales of severed groundwater estates, I think by and large, particularly west of I-35, are going to be relatively rare from this point forward. The landowners recognize that those rights have value and that the value of that water is only going to appreciate over time. I think that's conventional wisdom. And so instead what you see are typically now, or at least what I've seen a lot of, are leases. And so the issue is how are we going to sever the estate, how are we going to treat the estate, and then how are we going to treat, what kind of transactional structure are we going to build around transferring the right to that estate. One of the trends is to use the oil and gas model for leasing purposes, and that is to create a groundwater lease along the lines of a mineral lease, where you have the groundwater owner, the groundwater estate owner, and then you have someone who's paying based on the quantities of water produced, and in some cases they're paying a fixed annual fee plus the quantities of water produced. And in a lot of those transactions, sort of the driving compensation for those, again, in the same context of mineral leasing, is royalty payment. Those transactions come with their own nuances and complications too. To your point, I can open up the Wall Street Journal and I can see what the value of West Texas Intermediate is today, and I can see what a December futures contract is going to cost me if I bought one today. And even to a certain extent for production agriculture, it's a little bit longer of a decision process, but I know what the value of that water is today. And I can make a calculation of what the value of that resource is for a royalty payment in a mineral interest context by even doing some napkin sketch research. I open the Wall Street Journal, I look what the price of oil is trading for, I take a look at production records, I make some simple multiplications, and I know what the royalty is, generally speaking, that I'm entitled to. Groundwater production is completely different. A royalty entitlement is only as good as the information you have access to, and when you're trying to determine the value of the royalty, I can't open up the paper and see what Ogallala Water is trading for on the Chicago Board of Trade today. And so there is a much more heightened level of activity and involvement on a landowner standpoint, on a groundwater estate owner standpoint, in ensuring that they're being treated fairly in transactions that involve royalty payments for the production of groundwater. That in and of itself sometimes changes the trajectory of the transaction away from a leasing of the estate to a simply purchase of produced groundwater at the wellhead. And really what drives that is it's a cost-benefit analysis. It's how much tolerance for risk that you have. If you have a lot of tolerance for risk, there could be a tremendous upside in theory on agreeing to royalty payments for the leasing of your groundwater estate. There also could be tremendous volatility. There could be buried cost of litigation and aggressiveness of activity with the groundwater estate producer on whether or not you're being justly entitled. The contrary is that if you are settling into a water sales agreement of some type, you've got long-term stability, you got predictability, okay, they're going to pay me X amount of money per 1,000 gallons of water produced, and I can go out to the meter and I can see how many 1,000-gallon units have been produced, and I can make a napkin sketch of what I'm entitled to. So to me, that's if there's a trend there and what drives transactions involving groundwater estates, it's one of the biggest ones that I've come across.
Really interesting. Okay, thank you. Kristen, how do some of these changing landscapes affect the GCD permitting landscape framework?
Right, and I'll take a step back for a second. One trend that I have seen, and I think we've all seen on this topic, is based on historic users in unregulated counties, a lot of them in West Texas and other areas where there aren't GCDs, we have seen a lot of those historic users say, hey, we want some certainty, some long-term planning certainty, and be in favor of having GCDs. So there's been that, I think, dynamic change. I think previously, there were conversations about, we want it to be unregulated so that the market can continue. But now, like I mentioned, we're seeing those historic users say, wait a second, I want a protection of my investment. And through that, I want some long-term planning certainty that occurs at the GMA level. I want to know what this resource is going to look like in 50 years, and the GMAs and the GCDs are planning for that. I want to be involved in that stakeholder process. And so we've seen that with Reeves County GCD is a good example in that market. We have also seen the groundwater study in Valverde County and what's going on there. So those are some exciting things. I also know that, a lot of the historic users and for some of these, groundwater leasing and transactions projects have said, we like to partner with the GCDs to have the science. We want to see the science because we need to know if we're going to invest in this area, what it looks like. What are the resources and the hydrogeology look like? So that is something I think from a global perspective that transition has occurred over the last few years. And as far as when you get specifically into the GCD permitting framework, one dynamic that I've seen that I think is obviously positive is previously there were some issues across the state of, potentially tying up water, speculative use and whatnot. I think we're seeing some of these transactions now occur, and now we're seeing where we're not having, large groundwater permit requests that don't have really the end user. We're seeing now we've got the leases in place, they're providing them to the GCD in the permitting process, and we have the transactions have found a way to say, okay, look, this is the amount of use, and stair step into it. So for example, we're not saying we need 50,000 acre feet tomorrow, but we're saying we need 50,000 acre feet in 20 years, and learning how to make sure that we work with the GCD so we're not tying up water and keeping others from using it. Another way that actually historically over the last couple of sessions was that change where the GCDs in their permitting are having to look at the actual use in addition to how much is permitted has been a fantastic shift, because obviously if you've over permitted but your actual use is under what your DFC and MAG calculations show on a long-term basis will work for your district, then you're going to be good to go. And we're not going to focus only in on that permitting number. We're going to focus in on, okay, let's look at actual use and let's see overall how these trends are working out. So I think obviously it's all for positive. One thing I'll mention too is I know in many areas of the state it's a positive relationship with these large scale projects, municipal, oil and gas, other industrial uses. It's a positive relationship with that GCD, and those permittees are wanting to come in and do the right thing and say, hey, we all have a stake in this, and we all have a stake in making sure we have a long-term planning commitment here to our end users and obviously to the resource itself. So it's all been positive from my perspective.
And John, what role does groundwater valuation and project financing play in the question of ownership?
Well, the question of ownership, there's always obviously the legal definition of ownership, which I guess new court cases, because we settle that further in Texas, but there's this question of, do you own the groundwater under your land? And the Texas courts have pretty much said, yeah, that's the way it is. But in economic principles, there's sort of this term that's used, do you own the asset or does the asset own you? And it becomes kind of interesting when we're talking about groundwater and ownership, not from a legal perspective, but from an economic perspective, is that you really only own something where you can derive value from it. And this gets into Jason's discussion in terms of, well, what's the value of the groundwater under your land when you're not quite sure what the market is? You can't go to the Wall Street Journal. You can't go to the Chicago Commodities Board and say, well, what's the value of a gallon of water in the Carrizo-Wilcox area, And that becomes important in the sense of, when you look at your assets that you own as property, such as your land or in Texas groundwater, and you go to the bank and you say, I want to borrow against that, it really brings up this interesting question that the bank is pretty sure they know what your land is worth. That is, if you went out to sell it, they think, I could get this much for it. If you're talking about groundwater, not from the groundwater estates where groundwater's been severed from the land, but in a private property owner owning 10 acres and wanting to actually finance something by putting that on the line, there's not many banks that will float that loan. And so from that perspective, the economic principle of groundwater ownership in Texas could be one where, yeah, you can get into a good deal on the Vista Ridge project, and you can basically allow Blue Water to come in and set up all the infrastructure, and then you can get $46 an acre foot if they pump it, which is a revenue source, which is economically, yes, you're owning it, but could you have done that on your own? And the answer is probably not, because you would have had to set up all the arrangements, you would have had to put in the infrastructure yourself, you would have had to get the contract with San Antonio Water System, and so forth and so on. And so I think when we start looking at this, the term of you're owning the groundwater, there's the legal definition, and then really thinking about it in economic terms of how much does a landowner really own the groundwater. If they're using it to produce a good, such as irrigating crops, producing oil and gas, some industrial process, yeah, clearly they do. But if they're using it and trying to use it as an asset to borrow against it to put in some infrastructure either to develop the groundwater or develop something else on their property, there's a real question of what is the financing for that, and are there any mechanisms to finance it other than self-financing? And that's sort of one of the things I see there when you start looking at owning this asset is, can you do something with it? And it's almost as if what it seems like is Vista Ridge tends to be the model of you can do something with it if some other entity aggregates a lot of the groundwater resources and brings them into a big group, and you become part of that group. But as an individual, you probably don't have much power to move that market at all or decide what the value of your groundwater is going to be, unless, again, you're using it directly to produce a good on your own property.
And so I have just a question that popped up in my head here. So let's go with what you just said about value, and then let's talk about the individual as well as the groundwater policy angle. Do people have a realistic, from the individual perspective, a realistic idea of the value of their water? And that in many cases, there's not much value to it until they can find a place to produce it. And that question's for Jason.
Yeah, I get asked this question a lot, and that is, how much is my water worth? And if you're the landowner, typically my answer is, how low are you willing to sell it for? And if it's the entity that's trying to acquire the groundwater or the groundwater right, the answer to the question is how much are you willing to pay for it? There's a developed industry in the real estate business where you have comparable sales, and you use that to sort of triangulate what might be sort of a compass, a guideline for what you as a seller or you as a buyer are willing to pay for a particular piece of property. And there are several folks that probably disagree with this, but I don't think that is necessarily an analogy. Not the least of which is, emotion. You can't put a value on emotion. And folks that sit on groundwater assets are, just like land, but are emotionally tied to that. And in many instances, they see legacy value to that. And like I said before, they also, see conventionally that this resource isn't going to become devalued over time. It's only going to become in more demand. And so am I willing to take this now? Well, if somebody's willing to pay me X dollars per acre foot for this groundwater right, then I bet they're willing to pay me 10% more than that. And if they're willing to pay me 10% more than that, I wonder if I can squeeze them for another 5. And if they don't, then somebody's going to come knocking on my door in about 5 years, and I bet they'll pay that price then, and maybe I squeeze them for a little bit more than that. And that's not a function of greed. That's a recognition that that's an emotional asset, and it's tough to let go of. And so I too think that also plays into sort of the complexities of assigning value to groundwater. It's not a traded commodity. It's as much of an emotional based transaction as it is a quantifiable one as far as value goes.
Kristen, do you see, just going off what Jason said, do you see this, I don't want to say lack of understanding of the value of water, but the lack of clarity of the market, the lack of clarity of the value at the groundwater district level and the policy-making level? Do you think that that lack of clarity sometimes creates more political stress, more difficulty in determining what the appropriate regulations are, or changes to state policy, or at the local level, at the GCD level? Have you found that lack of clarity impacts?
Yes, I think so. And like we discussed, there's certainly a moment at the beginning of, at least when, I have a landowner, for example, call, and it's a perspective adjustment in a lot of ways and expectation adjustment. And sometimes that's higher than their expectation, and sometimes it's lower. But to your question about involvement with the GCDs, absolutely. That's something that, in terms of the permitting process process, and that's one thing I'm seeing too. A lot of the landowners lately, in the last couple of years, I'd say, are saying, I want to go in and get the permit. I want the permit as the commodity for me as the landowner, as opposed to, for example, the oil and gas company that traditionally may have done that before then. So I think that's been a neat shift I've seen where the landowners have come in and said, okay, I want to use that. It's a marketable resource, and working with the GCD from that perspective. And part of that is also, having those realistic expectations about the permitting process, how long that takes. I know, in some of the requirements that GCDs have in Chapter 36, that's not something that can happen in a week. It's a month or months long process to go through the science aspect of it, depending how large the permit request is. So that's also an expectation adjustment that I usually do in the beginning, that, okay, if you're in a GCD, there are statutory requirements that these districts, statutory mandates that they must meet in order to process your application. So it's not going to be something that's granted tomorrow. And, you will have to go through the process, and it's a valuable one, but be patient and work with them, and we'll get you where you need to go. So I think that I've seen that. One other thing to kind of go off of what Jason said is I've seen a trend in terms of the transport of water. So in other words, previously, I think, like we talked about historical leasing, not to say it wasn't sophisticated, but it just certainly, there were a lot of areas uncovered. Now I'm seeing where that transport, so in other words, when you're leasing the right and you're allowing a lot of that right-of-way, a lot of the pipeline to be laid across a property, obviously it's pushing now that price up. And also I'm seeing leases that are multi-structured where there's a price per thousand, for example, produced, and then also the price for the pipeline that's running across the property. And so we're looking at situations where, okay, some of these pipeline companies and whatnot are looking and saying, all right, I'm now having to pay more for groundwater to get off this piece of property than I did, because the landowners are now coming in and saying, wait a second, you're going to crisscross, and I want to be paid for that, where previously they could, similar to oil and gas, they could do what they wanted with the surface. Now a lot of these leases are having that built into it, and so some of these oil and gas companies, for example, are utilizing the TxDOT right of way for that saltwater pipeline aspect of that's in the statutes, to allow them to have some of their water. It's not even oil and gas; it's the water use for oil and gas. So it's now a creative market in terms of the transport as well.
John, do you have anything to add to that, or? No. You should. You're an academic. You have lots of things to say.
No.
Okay. Well, I'll ask one last question if we have time, and it's a big question that can't be answered today, but it'd be fun to start the conversation a little bit. Is it possible to create the best groundwater policy in the state of Texas if we really don't know what the markets are? I mean, we're responding to markets. So let me go back in time when I gave you the overview of my kind of time in water. So about a 14-year period, and when I first started in water, that was right after Senate Bill 1, and so you saw a lot of groundwater districts come to fruition, and really, I'm a political person by nature, what you saw is the groundwater district as a defense against a resource going to market. And then we've had kind of an arc or a pendulum swing. And then around that mid area, then you start to see the state go, okay, guys, you're going to have to find a middle ground. And then I feel like just in the last couple years, what we're seeing is a full swing to the other side to say that groundwater districts are really there to facilitate a transfer. And I think it's somewhere in between. But again, I just feel, and this is my own personal opinion, and I want your all's opinion on it, if we don't know what that market is, how do you really respond to it from a policy perspective at all? And how do you define the market?
Can I jump in?
Yeah.
Okay. I did work in an area, it wasn't on groundwater, but it was in a situation where, unbeknownst to them, they created a non-point source pollution trading market as a matter of just necessity that evolved pretty well. And some of the lessons from that were simple things that you learn about markets. Markets don't function unless there's transparency in the market in terms of price and value of what you're getting. Markets don't work unless there's ways to measure actually what you're trading and what the pool of the resources, that is, the amount that's available on the market. And so with those kinds of things, you realize that the question, I don't think, is can you set good policy without having a functioning market? I think the question in my mind comes down to what policy do you need to have a functioning market? And this is one where I'll jump in and put my foot in it and say, I think there is a good analogy to the real estate market, is when we think about it, the real estate market, there's no Chicago Commodities Exchange Board for real estate. Rather, you sort of know which neighborhoods in San Antonio are worth what much, depending on the houses. And the reason that works is because you have real estate agents that are licensed by the state of Texas, operate under regulations in the state of Texas, and basically requires you, if you're going to go out and put your shingle up and say, I'm going to sell real estate or I'm going to be a broker, you know what you're doing and you know how to have some level of valuation of the property. Well, we don't have that with groundwater. We don't even have that with water. And so if we were going to take a step and say, well, we need a functioning market to set policy, I would say, well, take some steps to actually create something analogous to real estate agents, which some other states actually have this for water rights, where they have water rights engineers, for example, that are required to be licensed and certified. So at least you have something that has some consistency across the state in terms of how you're approaching this valuation, and then recognizing it is a highly localized market. And so rather than having one centralized, commodities exchange board, you basically have a mechanism to make sure that all the transactions are occurring in as transparent and fair a manner as possible. And so it would be creating, in essence, this whole new class of middle person that would potentially be analogous to real estate agents, and then there would have to be policies that require, develop the licensing and regulation of such, so that they could start functioning across the state. So that would be my suggestion, is look at what it's going to take to create a transparent market, and maybe look at some others that by themselves might not be transparent unless the state had stepped in and created the appropriate regulations and licensing to get the market going.
Go ahead, please.
Yeah, I'll just make a brief statement. I think your question to me is an example of how local control works. How in the Houston area, the issues that are going on are so much different than North Texas or West Texas, and Dallas-Fort Worth market is obviously a lot different than West Texas. And so to me, that question really sums it up to show how local control and how GCD and that local control aspect works, because it's not a one-size-fits-all. So I do think the challenge there, because that's an example of how local control works, I think the challenge is to say, okay, but when we do legislation, we have to be sure that we're not going to have because we're trying to address a problem down in the Houston area, for example, we have unintended consequences for another area of the state. And that's something that's important to me to make sure, as I'm reviewing legislation or some of the issues, is to make sure that, okay, well, wait a second, this is working fine up here, so if we're trying to address an issue here, let's make sure and either try to bracket that issue out, or let's make sure that we're really thinking about how that's affected statewide, and we're not addressing, maybe one or two examples of litigation that affect everybody when the rest of everybody else is doing okay with the way it is. So that'd be my observation.
I think it's a very good point, fair point. And Jason, do you have any?
Yeah, I agree. Transparency is the key. When you're selling dirt, you have an MLS, or you're selling dirt in a house, you have an MLS. And folks across the state that might be interested in that particular piece of property get a full description of what that property is. And there is a sales price that's associated with it. When it's sold, that data is also recorded, and so agents and brokers have access to be able to determine how that transaction fared in relation to the asking price. But like any other piece of real property, groundwater, even with, compared to somebody, 6 miles over that might have engaged in some similar type of transaction, there's a list of issues a mile long to consider about what the value of that resource should be. And I'm talking hydrogeologic issues, I'm talking water quality issues, location to your marketplace, your end user issues. All those affect the terms of the deal and what the actual value is. So I agree. If there's a way to add transparency to those transactions, it helps the market I also think, though, that we're not going to have a true efficient market for water resources, and particularly groundwater, until we have a more stable regulatory environment, and that's from the legislature on down to groundwater conservation districts. You're right, the pendulum has swung. And as long as the pendulum's swinging, that creates questions and uncertainties for both the buyer and the seller of what they're selling and what they're buying. And, as a purchaser, if I'm investing, tens of millions of dollars into a project, I want to know that 50 years down the road, I'm still going to own what I think I'm buying today. And as long as that pendulum's swinging back and forth, that makes it a very, a much more risky proposition than if we had a bit more stability in water policy in the state. And I think until we get that nailed down, we're going to see turbidity or inefficiencies in what we would all consider, I think, to be a water market in Texas.
Well, I think those are great answers, and I do think we're lacking clarity from a policy position on the market side, and I do think, I like groundwater districts, and I know I've worked in many of them. I know they can be very difficult, and no offense to anybody, that's your job to be a little bit difficult. And they can be time-consuming, and you have to have patience. But I do think they are an interesting balance as you develop a market. I mean, I believe the Vista Ridge project did succeed or get this far based on what was some stability in the groundwater district area where the project's located. So it kind of ties all three things together. I do think, and I'll finish up with Jason's point, that the more you swing that pendulum on the state level, the harder it gets. Tweaking and stability is actually really pretty important, especially from a financing perspective. It is very difficult to have a discussion with an investment banker who's like, well, last year it said this, and this year it said that. That really does hurt market opportunity at the end of the day. So I hope what comes out of this a little bit is that I've never believed that there was a groundwater district versus water market fight ever. I don't think that exists. I think there are ways that we can function together to protect the local community as well as provide the economic engine of Texas with what it needs in terms of resource. I think those things are possible together. So I really appreciate the panel today. I think it was a great one, and super smart people, and I really appreciate your time. And questions?
I'm going to package a handful of questions into one, if that's okay, because I think we only have time for one. Are y'all ready?
Yeah.
Okay, so the first question is, does severing a groundwater right change the takings analysis or the parcel as a whole standard? And the second part of that, just as a thought, is, do we need caps on production from aquifers to facilitate a market? So I'm going to put those out to y'all.
Sarah, do you mind reading that first question again? I object to the multifarious question.
Sure. That first question was, does severing a groundwater right change the takings analysis or the parcel as a whole standard? And in fairness, there was another portion of there in terms of severance that also is, if a landowner wants, let me transition to this one. If a landowner wants to get a permit as a marketable item, is that considered a beneficial use?
I'll answer at least that last question. Previously we had said no. In other words, where it's that speculative use for where you don't have the end user identified. Because in reality, while I understand that and you want that commodity, you also you're tying up a chunk of water with for the sake of tying it up, so that you can potentially use that in the future. I know we've got case law on that about conservation as well, so there's another argument there. But so previously not. But what I'll say is that yes, you can continue to do that But you will need to be creative. That landowner will need to be creative in how they are proving up that beneficial use in that permit application, whether that be a letter of intent or something to that effect. But you certainly, I wouldn't want to go in and represent somebody with just a speculative use. I want this marketable asset. I truly do think in that beneficial use provision in 36, we have to identify at least what that use will be. And even if we taper that out over a number of years, we have to have some sort of end use there.
And any thoughts on whether we need caps on production from aquifers in order to create that stable market?
Just from basic theory is that if you have an infinite resource, it means it's not a scarce resource, which means it has no value. I think there's physical caps. I mean, as the Ogallala is proving out, there are physical caps. And so the question is, do you want the caps issued as regulatory caps, or do you want to just let them be as, I guess I'd say, what the physics allows? So the physics does put caps on production. Maybe that's good enough. But if you want to drive the market price up, oh yeah, put regulatory caps on, because the less there is the resource, the more scarce and the more valuable it becomes. And that's true whether you put land use zoning that prevents development, or putting caps on groundwater production in systems. So.
Yeah, I'm going to agree. I think as far as a valuation standpoint is concerned, it's going to be difficult to peg a value to the resource as long as there is a question about how exploitable that producing horizon, so to speak, that aquifer is. When you have a cap on it, the quantities you're working with, then it becomes there becomes more of an analogy between transactions than when it's, at least in theory, a potentially bottomless source of water.
My name is Gerald Lyda. My family owns and operates a cattle ranch in Pecos County called La Escalera Ranch. It's 223,000 contiguous acres. And we recently secured a very comprehensive water study across the ranch, conducted by JSAI of Albuquerque. And it revealed that under 70% of our ranch is a very pure, less 1,000 TDS or less quality water in the Capitan. We're interested in marketing that water out of the Capitan Reef aquifer, and we are ready to market it now. I would like the panel to discuss the possibility of a marketing strategy involving the reservation fee at the beginning here for those entities, agencies, or private investors or municipalities who might need some lead time to develop funding, design, and construction of any kind of infrastructure to get down to our ranch in Pecos County.
I think what you bring up is another trend, that reservation fee. That is something that's fairly new in our world. I do think that that's a value, and I do think, especially based on what you said and the number of acres, I would think that your project sounds like it's very marketable from the sense of the stability of that many contiguous acres by one landowner or one group of landowners. And so all of those factors it has that marketability from the front end. In other words, that reservation fee. So I think you bring up a good point, and I think that's a great idea. As far as now going back to our issue, what it's worth, I don't think we can answer that. It's like I mentioned, it's fairly new, so we don't have a lot of transparent examples out there of that type of fee in the front end. But I do think, especially in your area, that you can look at a few other examples.
Well, our idea, our plan here is to provide different water packages here that would be affordable here to smaller communities in West Texas, as well as the large cities in West Texas, as well as private investors. So we have different packages here that would provide takers of that water to secure just about any amount of water they need. And appreciate your insight. But I'm familiar with the city of Dallas. That's they have a reservation fee assigned. I believe they sell water to some of the bedroom communities around Dallas. Is that right?
That's correct, yes.
Yeah. Ours is structured kind of differently. It's the idea that interested parties could reserve water for emergency or drought use, use in times of drought, and maybe even invest in it and hold on to it and pass it on, or sell it later on as a revenue stream here for smaller municipalities or counties or whatever might be interested in doing it.
I'm so sorry to interrupt you. Thank you so much for your question. Unfortunately, we are over time, and we do
Thank
need
you
to
very
get to
much
lunch. But I wanted to make sure that we have a moment to encourage you to visit with these panelists after. Join me in giving them a big round of applause for a very interesting discussion.